The Indian justice delivery system has somehow taught itself to speak the language of the rule of law and the language of economy in the same sentence, while his own bench, in his own words, was still teaching itself to speak one language at a time. I find myself ruminating over that exchange quite often, because at the end of the day, it is not a compliment to India alone. I believe it speaks volumes to what forums such as this were made possible. The chance for the jurisdictions possesses the fluency to become a second language for all of us over time. The enormous growth that our nations are expected to sustain cannot solely arrive by the luck of geography or the accident of resources. It is built deliberately out of institutions strong enough to be trusted. Perhaps numbers and statistics can make the point better than words alone. The BRICS and associates nations today are home to more than 40% of humanity and account for something close to 40% of the world's output measured by purchasing power, larger by that metric than the G7. Within that grouping, India continues to be described year on year by the International Monetary Fund as the fastest growing major economy on the planet at a pace nearly double the global average. The scale at which our country is progressing, and this holds true for each of the BRICS plus nations, owes itself to the nature of our institutions, the judiciary being chief among them. Institutions are not scaffolding we erect around growth once it has already begun. They are its architecture. Take the architecture away and you put what looks like a rising economy is a stack of good fortune waiting for its first storm. This architecture, upheld primarily by institutions such as the justice delivery system, offers three things: trust, predictability, and stability. Each a direct byproduct of studied allegiance to the rule of law. It is this and nothing more mysterious than this that allows any economy, including India's own, to flourish at the pace we have already put a number to. In fact, I have attempted to coin a term that would perfectly describe the marriage between the rule of law and how it permeates favorable economic conditions. Nyayanomics, or more simply the economics of justice. It is a fact that consistent adjudication and trust in the process reduce the cost of each transaction built upon it, thereby leveling the playing field for market forces and in turn making way for growth. No BRICS plus economy, including India, has achieved growth solely through its resources. Our development has been proportional to the enforceability of our commitments. Allow me to transition from the theoretical to the practical, as a promise is most readily admired in abstraction, but is not challenging within a real courtroom, where a commercial party waits to ascertain the validity of its agreement. Most of those who are well conversant with the Indian judicial system are aware that the Supreme Court in 2012 in Bharat Aluminium drew a line that international commerce had been waiting the better part of a decade for, namely that the Indian courts would no longer reach into an arbitration seated outside India simply because one of the parties happened to be Indian. The seat, not the litigant's address, would decide whose courts had a say. Less than a decade later, in Wind Solution, the Supreme Court went further, holding that even two Indian companies were free to choose a foreign seat for their own arbitration, if that was the bargain they had struck. Party autonomy, the court held, did not stop being party autonomy simply because both parties happen to share a passport. More recently, the Supreme Court has spent its attention on the question that decide whether an arbitration clause survives contact with the real world. In Cox and Kings, the group of companies doctrine has been applied in the case of a company that never signed an arbitration agreement and can still be bound by one because of how closely its conduct was woven into the bargain. In a 7 judge ruling the same year, the Supreme Court sustained the arbitration clause notwithstanding the non-payment of stamp duty on the deed of agreement. In both, the court reached for the same instinct, namely that form should not be allowed to defeat intention and a technicality should never be permitted to unmake a promise that parties actually meant to keep. The same instinct runs through our insolvency jurisprudence. When the Supreme Court upheld the constitutionality of the Insolvency and Bankruptcy Code and later affirmed that the commercial wisdom of a creditors' committee deserves primacy over years of open-ended litigation. It was making the same point in a different register, that is, capital recycled quickly is capital that returns, and capital trapped in litigation for a decade rarely does. None of this happened by accident, and none of it happened without cause to old habits of judicial caution. But the results have been different and difficult to dispute. Across the years, these judgments span. India rose from among the bottom quarter of the World Bank's ease of doing business rankings into the top 100. And enforcing a contract in this country stopped being a byword for delay. To my mind, a courtroom that keeps its words quickly becomes a country the world is willing to trust with its capital. Ladies and gentlemen, at this juncture it is worth pausing on what this forum actually represents, because I suspect we understand it. This gathering, as rightly pointed out by Mr. Naganand also very briefly, represents 11 legal traditions of common law and civil law, hybrid systems built on older customary roots, and learning to place trust in one another's institutions without first flattening our differences into sameness. That, to my mind, is a harder achievement than uniformity and a more durable one. This initiative is currently progressing within the framework of the bloc itself. The New Development Bank did not merely adopt a rule book from external sources. Rather, it developed its own rule-bound and multilateral, accountable to its own members instead of institutions designed for a different era. Such efforts also constitute institutional capacity building, which coincidentally aligns with the very theme selected by this forum. A gathering of this stature ought to leave behind more than well-chosen words, mine included. Let me modestly propose two things for this forum's consideration. First, a BRICS plus judicial fellowship, allowing every career judge to sit very briefly in one another's courts. And second, a shared jurisprudence repository, drawing on India's own considerable investment in digitized case law, so that a judgment written in New Delhi or Brasilia or Pretoria need not wait years to inform a bench elsewhere facing an identical question. If there is one phrase you absorb into your vocabulary this morning, let it be Nyaya Setu, a bridge of justice that connects 11 legal traditions which have mutually agreed that trust should be cultivated deliberately rather than awaited positively or passively. Let me reiterate that the rule of law is the edifice upon which civilization constructs their aspirations. It is the invisible thread that binds the hope of progress to the reality of justice. Economic resilience, like a sturdy tree weathering the tempests of global uncertainty, roots itself in predictability, fairness, and trust. Innovation, the spark that lights the corridors of our collective imagination, thrives were shielded by legal certainty. Sustainability, our solemn pact with generations yet unborn, demands that our legal systems evolve to safeguard not only markets but also nature and human dignity. The BRICS Plus legal forum is uniquely positioned to champion this vision. Together, we embody the dynamism of emerging economics and the wisdom of ancient civilization. Let us therefore commit to a future where institutions are not fortresses of formality but breezes of trust, where our united efforts illuminate a path of mutual harmony and prosperity. In closing, I extend my warmest congratulations to the organizers of this forum for maintaining over 11 editions, what many conferences claim but few accomplish. Furthermore, I commend the selection of this year's tectonic theme, one that is as timely as it is timeless. Let me end by asking each of you to carry one thought with you, that the strongest economies of this century will not be ones with the most resources beneath their soil, but the one whose courts and institutions honor every promise made about it. Thank you very much for inviting me.